Hi, Legal Advice is here. It's time for a special interview with DANI AHN. She's been a favorite of you viewers for a long time now, so we're going to bring her up here to talk about the upcoming Salt Lake County District Attorney election, where she is running as a candidate against longtime incumbent Sim Gill. What we'll be doing is we'll be showing you like an interview that she did recently and then getting her comments and talking about other parts of the upcoming election. DANI, good morning. How are you doing?
I am doing just well now that I'm here with you, Jeff.
Well, for those out there that just don't know who you are and what you're doing, give us a little bit of a background.
Sure. So I'm a civil litigator. I graduated from the University of Utah. I'm running for Salt Lake County District Attorney because our current district attorney is doing nothing. And as a result, there are a lot of victims who don't have a voice, and I would like to provide a voice for them.
And you have a connection here with Korea as well. I know you used to live here in Korea back in the day, here in Busan, where I'm at. How has your experiences in life, living abroad, living at home, prepared you for this upcoming election?
Well, my entire background is very unique. I had a really rough upbringing. I came from a broken home with a lot of mental illness. And it was really challenging because my sister had a serious mental illness and so did my dad. And we actually were homeless at one point. And I started singing and working to overcome, serious poverty. And fortunately, life worked out. I went and I served an LDS mission in South Korea. And so I have a very broad perspective that I don't think most attorneys have. So when I went to law school, for example, I remember we were discussing issues involving property crime being considered a life crime, or the difference between prosecuting a property crime and a life crime. And I was appalled when someone said, well, we shouldn't pursue someone in a car because that's not a life crime. And we should only enforce the principle of self-defense as it applies to the person, not as it applies to your property. And to me, that was especially abhorrent because when you have nothing and you've worked your entire life just to purchase like a cell phone or a car, regardless of how bad that car may operate, that is your lifeline. That is everything you have. That's everything you own. And for that to be infringed upon is just abhorrent to me. So my perspective is built on this notion of, look, we're all human beings. We all have our challenges. We all have our backgrounds. But the law is valuable to enforce for the sake of enforcing the law. The law exists for a reason. And I always give this example. When you go down a really, really steep slide, feet first, it always says cross your legs and put your arms this way. Well, there's a reason for that. And if you uncross your legs, you'll learn why very quickly. You will give yourself an involuntary enema if you do not cross your legs. And so, as a civil litigator, and I'm sure you know this as well, or at least you've experienced and seen this, where there seems to be these arbitrary rules or laws, and you wonder, why are we so serious about enforcing those laws? And then you learn the hard way why, when that law is not applied to you or when you're not protected from the lawbreaker. And so having that background, I think that I'm particularly poised to take on this position and take on this role where I'm leading other attorneys. And, it's so funny because one of the complaints that I've heard is, well, and we'll get into this later, but you lack experience. And one of the reasons why people have such tremendous turnover in litigation and in law firms is because you have experienced attorneys and experienced litigators trying to manage other attorneys. Just because you're a great attorney doesn't mean you'll make a great manager or a good leader in your firm. And so we can discuss that further. But given my background, I do think that I have a unique qualification where I can understand both many of, if not 90% of the defendants that come across, the DA's office. And I can also understand the position of many of those younger litigators, younger attorneys that need to be hired for that office to replenish and to, get the job done that that the people have hired us to do. So it's an interesting situation, but that's a little bit about my background. So,
well, what was the one thing that made you wake up one morning and say, I'm going to run for Salt Lake County District Attorney?
when I found out my opponent was running unopposed, I said, like hell he is. And I went ahead and I filed because I had two friends in one in law school and one in undergrad who were violently sexually assaulted. We took both of their cases to the DA's office on separate occasions. One of those cases had video evidence, and we were told that there wasn't enough evidence to even bring charges. Since then, I've learned that that's a very common phrase. And it went from not having enough evidence to bring charges to the DA now saying, in the interest of justice, they're not going to be bringing charges against a defendant. And there's no further explanation. Generally, there's two reasons why you would decline charges. One is because it doesn't meet the legal standard to bring charges. Or two, there's not enough evidence to meet the evidentiary standard to bring charges. In either case, you would explain in a letter to the city attorney why it is you're not bringing those charges, so that they can either, so that one, they can inform the victim, right? And then two, if there is an evidentiary issue, they can possibly do further investigation to meet that evidentiary standard to say, oh, you needed this witness or X piece of evidence. Let's go forward with getting that before we charge. That all makes sense. But in these letters that have been being sent out from the DA's office, it just says, in the interest of justice, the state is declining further charges.
And because that happened to two friends that you knew, you decided that he's not going to run unopposed.
Yeah,
and
absolutely.
he needs an opponent.
Yes.
Well, you were recently at the Salt Lake County East Side Candidate Forum, where there was supposed to be a debate, as I understand, between you and your opponent, Sim Gill. And you have the video of that, and you want us to review the video and go over it. And let's do that right now. It's about a 10-minute video, and as I understand, it's you were speaking first, and then he is speaking after you.
That's correct. And this is an interesting, just to put it into context. I was told by the League of Women Voters, who had hosted this entire forum, that I would be speaking first and then Sim would be speaking. And that if Sim did not show up, my opponent, if he didn't show up, I would be able to take all of his time. Now, I thought that was the case on the West Side Forum, and it turns out he was able to video conference in and just send a pre-recorded video, which you and I both know it's a lot easier to come up with those witty remarks and be able to debate when you're shadow boxing, essentially. And that's basically what he's been doing this entire campaign. He's been hiding in his basement. He refuses to debate me. And so because of that, I said, all right, I have literally dozens of victims who want to ask him questions. And I have, thousands of residents who have questions for the DA's office. And I'm going to ask them, since the media is refusing to ask him these questions for whatever reason. And we can go into that later. But this was my opportunity to ask him the questions that I had gathered over the past, 7 months of running against him. So if it seems very stilted and if it seems like I'm reading off a piece of paper, it's because I am, because I wanted to be very specific in my questioning, knowing that I would not have the opportunity to rebut anything he said after me.
Well, let's hear the statements from both of you, and then we can discuss it further. And anytime you want to stop for any other reason, just let me know, and we'll pause the video.
Now presenting your first candidate for Salt Lake County Attorney, DANI AHN.
Okay, sorry. Good evening. My name is Danielle Ahn, and I'm asking for your vote this November. My opponent won't debate me, and although I've asked, I will not be allowed to speak after him, and I will not have the opportunity to respond. This gives my opponent yet another opportunity to hide from the truth which I'm about to share with you. I am giving Sim Gill the opportunity to show us what he means by accountability and to answer these questions honestly. After this forum, I will have these questions and answers available online at
www.daforda.com, or on my Facebook at Elect DA for DA. We are nearing the 1-year anniversary of the tragic death of 13-year-old Carl Finch, who was hit and killed by a driver who had marijuana in his pocket and THC in his system. That mother is crushed and that driver is out living his best life. My question to Sim Gill is, why will you not charge that driver with a felony?
So go ahead and pause there.
Last week,
Yeah.
So one of the issues, this is for your viewers who aren't attorneys. One of the issues that has come up and that's so frustrating about these charging decisions is that the DA is the only one who can charge felonies in my jurisdiction. Okay. So the city attorneys have to refer the case to the DA in order to have a felony charge brought against, in this case, a driver who had marijuana in his pocket, THC in his bloodstream, in his system. They did a blood test. He had hit this boy in a marked crosswalk on Halloween night and killed the little boy. And the DA, for one reason or another, is refusing to charge him with even a third degree felony, which is negligent, criminal negligence type standard, which is, manslaughter. So it makes very little sense to me, given the evidence and given, the situation and some things that the driver said after the incident, why they are not bringing those charges. I say all the time, there's a huge difference between 1 to 5 years and 1 to 15 years in sentencing. People always ask, why does it matter? Well, because if you're charging, let's say, for example, and we'll get to this, let's say you're charging someone for murder and you're able to secure a murder conviction, first-degree murder, that's 1 to life, right? And possibly even the death penalty in certain cases. But for manslaughter, it's 1 to 15 years. That's it. So you could, and we'll get into this, but you could potentially have a murderer out on the street within a year after committing the crime. So, or at least after securing a conviction.
Okay, should we continue the video?
Yes.
All right.
Sorry.
was the anniversary of Aaron Lowe's killing at the hands of Book. This case raises many questions for me as both an attorney and a concerned resident. Why did Gill's office offer Book so many plea deals prior to the shooting, especially after seeing his escalating violent behavior? Isn't it true that he would have been incarcerated at this time last year had prosecutors not dropped that second felony charge? Speaking of the Aaron Lowe's case, Sim Gill said that after that shooting, he wouldn't offer plea deals for gun-related incidents. Yet, in the past week, he's offered 3. How many other gun-related offenders were given plea deals in the past year? Why were plea deals offered to a man which included 0 jail time for a guy who had shot his girlfriend and who had beaten and killed his grandmother in California prior to moving here to Utah?
Okay, you can pause there. So
Yeah,
that's exactly what I'm talking about. So that guy, the plea deal, initially he had shot his girlfriend up in Rose Park in Salt Lake City, and he was intoxicated. So the issue was, could they prove intent, or was there some sort of affirmative defense that was available to the defendant? And when you look at the facts of that case, it is just so similar to everything that happened to his grandmother, what he had done to his grandmother in California before he moved here to Utah. Now, if you want to offer him a plea deal, maybe that was appropriate given the evidentiary standard. My issue is, was the judge informed of this? Because after they negotiated this plea deal, the guy walked. He shot his girlfriend to death and got 4 years of probation.
Wow.
I mean, I don't know. Does that sound fair to you? You tell me.
The way it's presented, no, doesn't really sound that fair at all. Yeah.
And this is just continuing a trend for Sim Gill, because there was another plea deal that he offered to a guy who had shot a real estate agent in the back 3 times, once in the groin, and then hid his body in a crawl space. Now, what ticks me off about this plea deal is it continues a pattern that I had heard of from multiple victims, where the prosecutors are bringing in the victims saying, one, saying you don't have to come to the preliminary hearing, and then negotiating a plea deal with the defendant in the preliminary hearing. And so the victim thinks, oh, there's going to be this preliminary hearing and then an arraignment because this is what they're being told by the prosecutor. They don't realize that the prosecutor is trying to make sure that they don't come to the preliminary hearing, so that way they can negotiate this plea deal with defense counsel, and then they can bring in the victim to give a victim impact statement at sentencing. But most victims aren't, privy to this. Most people don't understand the legal process generally. But what's particularly disturbing is I have one victim who's an attorney, and another victim, and his wife is a social worker. Their daughter was sexually assaulted. The DA's office did this exact same thing to them, where they pulled them in. They said, don't worry, we're not going to be negotiating a plea deal. But that being said, we do believe in restorative justice. So why don't you two and your 12-year-old daughter come up with some ideas to restore, to make this defendant, a better person? Never mind the fact that this defendant had just raped your daughter. Let's go ahead and see how we can make his life better. And so they did. This 12-year-old went out there, came up with really beautiful ideas of maybe 15 years probation and only 10 years in jail, maybe these things. And the parents had thought of these ideas. And I know that we briefly discussed it on a live chat, this idea of conferencing, where you pull in the defendant, it's all voluntary. And basically as a group, you come up with a fair punishment or a fair outcome. And you discuss the crime, and there's an element of healing there. So they had formulated all these ideas, and they were told, don't come to the preliminary hearing. Well, they didn't go to the preliminary hearing, and they didn't realize that a plea deal had been negotiated where they dropped a ton of the additional charges, and then also dropped the original sexual assault charge from a second-degree felony down to a Class A misdemeanor. Yeah. So he got 0 time in jail, and they were then brought in to give a victim's impact statement. And that's a pattern that continues all the way up to a murder case. With the gentleman who was the realtor, they pulled his family in after they discovered the body and had, they were moving forward on charges. They brought his family in and told all of them, family and friends, to vote and make a decision whether or not they wanted this case to go to trial. Now, for those viewers out there, just to be aware, you don't have a say in the progress of prosecution. The DA gets to determine unilaterally whether or not they're going to bring charges, which charges to bring, and then whether or not that case proceeds to trial. Now, victims have the right to speak up. Victims have the right to be there. Victims have the right to, discuss the case and to know the status of the case. But to turn to the victims and act like their voice mattered, that they had the choice as to whether or not to proceed to trial, and to use that and weaponize it against them, right? When they suddenly say, well, wait a second, maybe we should take the risk, and maybe this should go to trial, and maybe you made the risk of us losing sound way worse than it actually was. That then eliminates that from their, it takes away their ability to protest. It takes away their ability to say, wait a second, this is not justice. And that is happening again and again and again and again. And I have the text messages to prove it, where I have a prosecutor texting a victim saying, do not come to the preliminary hearing. The defense counsel is going to try and trick you. And for your listeners, the preliminary hearing is the lowest standard. We're looking at a probable cause standard, meaning it's kind of likely that something may have happened, okay? And the last thing that a defense attorney would ever want to do is pull a victim up and put her on the stand and say, please cry in front of the judge and tell the judge that about what happened to you. Because at that stage, the judge is deciding, is there a viable case or not? can you actually secure a conviction? Is it likely that, you're going to secure a conviction, or are you wasting our time? So, and then there's a discovery process and further investigation that occurs after the preliminary hearing. But to be telling a victim not to come to the preliminary hearing because the defense counsel is going to pull you up on the stand and try and trick you, that's very, very rarely the case. So I always recommend, if you can, go to the hearings and make sure that the prosecution is progressing in a way that you find appropriate.
Well, I hope nobody finds themselves in that situation, but if they do, that's solid advice, I guess.
Yeah, those rights exist for a reason. The other thing is, victims aren't being told that they have the right to counsel. Now, that doesn't mean that, counsel is going to be their prosecutor. What it means is that the counsel is there to make sure their rights are being protected through that process. And then if they also have some criminality involvement, it protects their rights in the criminal side as well. So definitely get yourself an attorney, have that attorney come with you to these hearings, and make sure that your voice is being heard by the judge, by the court, that you're being properly represented.
Well, let's continue the video here. We've got quite a bit more to get through here.
Sorry, sorry.
Let's move on.
Judge of that fact. Why did Simgill's office amend charges for a first-degree murder charge to manslaughter in the David Stokoe case, where the defendant shot the realtor in the back 3 times and once in the groin and buried his body, or at least hid his body, in a crawl space? Were there no other why were other charges against that defendant dropped? And really, could you not prove intent in that crime? Simgill's office asked for an extension on the Aaron Lowe trial. When do you think that case will go to trial? Or will his office wait another 9 years like he did with the Richard Christopher case? The one where the alleged murderer's son confessed in open court in 2017 to his dad killing 3 men and how he helped dispose of the bodies. Since I recognize that Simgill may not be able to respond to these specific active cases, regardless of how old they may be, I would like to ask some policy questions. How many violent offenses must be committed before a defendant is no longer qualified to be a part of your jail diversion program? We've seen a 46% increase in homicide in the past 4 years. That's 16% above the national average during that same time, and an 8% increase in aggravated assaults. How many Salt Lake County residents need to die or be seriously injured before you'll admit that your policies have failed? Hundreds of declination letters from June to July of this year say the same thing. In the interest of justice, the state is declining charges. What does that mean? Are those declinations a part of your diversion program? Why did it take you 4 years, 3 expert witness opinions, and 1 grand jury to make a charging decision in an officer-involved shooting? What are you going to do to address the toxic work environment in your office that's leading to so many prosecutors and so many attorneys and staff fleeing? How is it that a law student could recognize the obvious and inherent conflict of interest in charging protesters for desecrating your $64 million prosecutorial palace in 2020 and you couldn't?
So
isn't it true that you asked for a significant
context to that comment? So 2 things. 1, the jail diversion program makes no sense to me. Apparently he's giving like these plea and abeyances to a bunch of violent criminals and saying that this is a restorative justice program. Basically, it's catch and release. So I take in a criminal, I don't charge them, right? I intentionally choose not to charge them. I release them back on their own reconnaissance. There's no condition to be met. And it's really not clear to me how these criminals are supposed to reform or what metrics he's using to determine whether or not this program is successful, because it's certainly not a recidivism rate. And recidivism is usually judged within like 3 years. So did you commit a crime, similar crime within that crime family within the past 3 years? They're not marking that. There's no way to track that. It's totally made up. And my question to him is, are these declination letters that I was talking about before, where the DA is saying we're not going to prosecute this in the interest of justice, are those letters connected to your diversion program? Because according to him, no violent criminal should be in the diversion program. Well, if that's true, then why do I have all these declination letters on violent criminals where you're saying I am not going to prosecute these violent criminals? Are they a part of the program or not? One. And two, if they're not, why are you sending out these letters? That's issue number one. Issue number two, in 2020, the DA came out and made a charging decision actually pretty quickly, finding that this officer-involved shooting was justified. But Sim Gill has played to a very extreme left side of his base. And this was, of course, during the 2020 Summer of Love with Black Lives Matter in the Eric Chauvin case. Is it Eric Chauvin or Darren? Derek Chauvin. Thank you. Somewhere in between those two names. So this was going on during that time. The protesters came and painted his brand new prosecutor, DA's office, bright red. They came and splashed paint all over the building, defaced it with, all kinds of posters, and they were very upset. And there was some property destruction that was involved. But he decided to charge them. And he didn't just charge them, with desecrating his building, which cost the taxpayers $64 million. He enhanced those charges with gang enhancements to put away these protesters for life. At some point, the ACLU had to step in to defend the protesters from Sim Gill, which is insane because the ACLU and Sim Gill have been in lockstep on everything else. And this is where Sim Gill really just blew his lid. And my issue is obviously there's an inherent conflict of interest, and even in deciding to charge these protesters, but then to give them gang enhancements and try to put them away for life, that was bad. And I knew that was bad even as a young attorney. And, a first-year student in law school could have figured that out. So that's context to those two questions.
Okay, moving along.
Significant amount of funds so that the county council could build a big, beautiful wall around your building after that incident. My opponent will say that that I have a lack of experience because I'm a civil litigator and I haven't prosecuted criminal cases. But we've had the Sim Gill experience for 12 years and we've paid for it with our safety. When you elect a DA, you're electing someone with vision and leadership, not someone to try cases. My vision is simple and achievable. It's time that we end plea deals with repeat violent offenders. We do this by training our attorneys on litigation, not on plea bargaining. We reforge our relationship with law enforcement and we give a voice back to victims. Vote for me, Danielle Ahn, and I will show you this year what true accountability looks like.
That was a lot better than I remember it being.
Well, let's listen through Sim Gill's response here, and then we'll address other issues.
Now presenting your second candidate for Salt Lake County Attorney, Sim Gill.
Zero applause. Sorry,
Good
I just
evening,
realized
everyone.
that.
My name is Sim Gill. I've been a public prosecutor for 27 years. So I will answer this question for you. There is a difference between the two of us. I graduated from law school in 1992. My opponent graduated in 2019. She's never prosecuted a single traffic offense. And so the answer is, Ms. Ahn, it's called evidence.
Okay,
It
press
is
pause.
called the rule of law. It is.
This gets me. So first, he calls me Miss Ahn, knowing damn well that I'm married. So he's trying to insult me. Very rude. Second of all, he says it's evidence. Well, if it's evidence, why didn't you put that in your declination letters? Why did you not inform the city prosecutor, the detective, the victims that there wasn't enough evidence in these 180 cases that I have on my desk from just June to July of this year? That doesn't even account for how many declinations that he has sent out in this copy and paste format throughout the entire year. And as a matter of fact, we'll finish listening to this, but I actually want to review one of those declination letters and just read to the viewers what it says. And it is copy and paste form for all of these cases. So continue.
Is what we follow when we file charges because we have that authority. And that is something that comes from experience. So I've been a public prosecutor for 27 years. My experiences, I was a prosecutor at Layton City, Salt Lake City, for Salt Lake County DA's office, where I was on the arson fraud unit, where I prosecuted violent offenses, where I also led out on a series of cases, sexual exploitation for profit cases, which we now call human trafficking. From there, I went on to the civil side. And from the civil side, I was of counsel to the health department and spent half of my other time doing environmental crimes prosecutions. Most recently, we just got the largest settlement on a criminal fine, which was $2 million against a corporate polluter of our Clean Water Act. And so from there, in 2000.
Just to be clear, that negotiation was not done by him. So it's cute that he says, we did this. You did not do anything, Simgill, first of all. Second of all, this was done primarily through the feds. So the feds had already negotiated out a deal with the polluters in general, which they have to because EPA is going to get involved in these cases. And then it came down to the finer details once it hit the county level. But that's common, whether it be, a huge polluter or whether it be most recently, the opioid settlements. Basically, they had already come to a larger decision, and then it was going to filter down through the counties as to the specifics on settlement at a lower level. So for him to tout that as, some measurement of his experience or to hold it up as his own medal is disingenuous at best.
I was appointed as the chief city prosecutor for Salt Lake City, which was the largest municipal prosecutor's office in the state of Utah. And there I learned how to do budgets, how to do policy, and to work on creating innovative programs focused on restorative justice. In 2010, I had the privilege to be elected as the Salt Lake County District Attorney. The Salt Lake County DA's office is the largest district attorney's office in the state. We do approximately 16 to 17,000 reviews, screening cases every year. We file approximately 14,000 of those. Within that capacity, we are not only just the lead criminal prosecutors, but we also manage and represent a $1.4 billion corporation called Salt Lake County Government. We're legal counsel to the mayor, to the council, to every other elected.
I'm sorry, can we pause and go back? Did he say he that he manages the budget?
Within that capacity, we are not only just the lead criminal prosecutors, but we also manage and represent a $1.4 billion corporation called Salt Lake County Government.
That's the problem, Simgill. You think that you manage those funds. That's a tell right there. He is saying, I manage those funds. He does not manage those funds. He may represent the county and he may assist in the distribution and making sure that everything that's done in between is legal, but he does not manage.
We're legal counsel to the mayor, to the council, to every other elected. We work on tax policies, we work on ordinances. We sue and litigate on behalf of Salt Lake County. So we do litigation, like for example, most recently, we sued Big Pharma and recovered $57 million because of the carnage that they've committed in our community. Within that, we have almost 300 employees, 140 lawyers who are professionally trained, who take their job very seriously. I absolutely believe that you can have criminal justice reform without compromising public safety, that we can build a fair and just system. I grew up in India, and growing up in India, I know what poverty is. I know what corruption does to the soul of a community and the dignity of a people. We can and should demand more from our government, and when we think about public service, we can build better systems. I believe in the inherent goodness of people, I believe in the inherent goodness of our public institutions to make a positive difference in our community. I helped start the very first mental health court in the state of Utah 21 years ago, where instead of having mentally ill people just cycle through the criminal justice system, we reduced recidivism rates from 74 to 72%, down to 19 and 22%. We save money for taxpayers, and we keep an empty jail bed because the best deterrent is an empty jail bed and going after those violent offenders. Our pre-file diversion program has a 90% graduation rate with an 8% recidivism rate. Low-level offenders who can actually be transitioned out of the criminal justice system so we can save the resources to go after those who are a genuine risk for our community. This isn't a popularity contest. This is about hard work. This is about experience. This is about going and doing the right thing every time, in spite of whatever may be said against you or opposition you may have. That is the privilege of public service. We're at a time, everybody here is running for office. So let's look at experience. Let's look at competence. And let us restore that trust back in our criminal justice system, within our electoral system, within our public service. You are here because all of you have a role to play in it. This is a critical election at a critical time in our community. There's no time for extremism. It's about common sense solutions based on experience. My name is Sim Gill. I would appreciate your vote on November 8th. Thank you.
All right, that's the extent of the Salt Lake County East Side Candidate Forum that took place about a week ago, 2 weeks ago, if I recall correctly. As you said, you asked for a rebuttal phase of this discussion, and if here is your chance for your rebuttal, what rebuttal would you give to him if you had been given the chance at that time?
First of all, you did not do any of that. Your attorneys did. And part of the problem is that you refuse to acknowledge the work of your attorneys, and that's why they are leaving in droves. He said in there that that the office has 140 attorneys. It should be at least 200 attorneys. But the reason it's 140 is because of these bad policies. He has a policy that says that he will not pursue prosecution, or what is the policy? A prosecutor should not bring or maintain charges against a defendant that they believe is innocent, regardless of the evidence presented. Now, that is not a legal standard I ever learned in law school. And I'm pretty sure that's not a legal standard anywhere else in the United States. But that is his standard for screening cases. So out of the, couple thousand, I think he said 17,000, which if in my understanding is a misspeak, but sure. Let's say it's 17,000 cases that he screens. Let's say that he takes, 90% of those cases. Even in those cases, he's dropping charges left and right. So it's not like just because you're screening doesn't mean you're actually charging. And it certainly doesn't mean that you're moving forward to litigation and then on to a conviction. So, I mean, when he talks about experience as well, we've had the Sim Gill experience. I said it myself at the end of my speech. We've had that experience for 12 years. He talks about, restorative justice, not at the cost of our safety, but we've already paid the price, and we continue to pay that price every single day. And so here we have the opportunity to have a new experience, to try something new. And honestly, what I'm proposing, he calls me an extremist. What I'm proposing is not extreme. It's exactly the fundamental duty of the prosecutor to bring forward the evidence, to bring forward the law, and to secure a conviction and to secure justice for the community. Justice doesn't mean just, getting a conviction. It means to find the truth, to come to an understanding of the truth. And I'm sure Sim Gill learned all about corruption in India, but the corruption has to stop here. He has to account for his decisions, both on how he spent the funds that the county has given him, where the other funds have gone, why he's not prosecuting cases, why he's decided to implement these programs that put us at higher risk. You heard him say in there that he's only letting go these low-level offenders. That does not mean nonviolent offenders. And what does low-level mean? We don't know, because he's never defined it. What does recidivism mean? We don't know, because he's never defined it. Essentially, as the DA, you have the discretion legally to sort of You know, when you're on the playground as a kid and you all have magic powers, you pretend to have magic powers, and one kid will have the power to fly, one kid will have the power to see through things. And then there's always that jerk kid that has the powers to have all the other powers. That's essentially what the role of the DA is they can go in and say, look, here are the policies that we're going to implement. Here's what the public has to accept. And if you don't like it, tough. The only way to get rid of a bad DA is to vote them out. And that's what I am begging, pleading for voters to do this November, to put an end to this. I will not be trying cases. I have the experience to hire the right attorneys to come in and try those cases. And I have the collective experience of the entire DA's office to come up with policies that actually meet my overall mission. And I know that my attorneys have the competency to reach that mission if they're just given the opportunity and the encouragement to try.
Well, I mean, these are some pretty serious issues. The refusals to prosecute, the letters of declination, the length of time it's taking to even get to the prosecutions when they do happen, the length of time it takes to make the decisions not to in some of these cases, and the other issues that you've talked about. Why haven't these been reported in the media? I haven't seen hardly any of them in the Salt Lake media.
So there was one report that was done by a woman named Wendy Halloran. She did an entire series on these declination letters. And Sim Gill refuses to do an interview with her ever again based on their interactions. And as a matter of fact, maybe we should watch that too, because that is an interesting interview from Sim Gill where he sort of loses his cool with her and says, you know, this is an election year. This is an election year. Of course, there's going to be critiques on the work we're doing. And I'm like, Sim, this doesn't have anything to do with the election. This has to do with accountability. He's running on a platform of accountability, and yet he can't take accountability for his own actions or the actions of his office.
Well, the election is coming up about 2 weeks from now.
Yep.
What's the election date?
November 8th. So make sure you get out there and vote. Make sure you're registered. If you get a mail-in ballot, mail it in. Make sure it's postmarked by the correct date. If you're not sure it's going to be postmarked by the correct date, go and drop it off in the ballot drop box where they can receive your ballot.
And any final comments? You're always welcome here. And if Sim Gill wants equal time, he's welcome to it as well. Be happy to have him on. Haven't heard from him yet, despite the number of times you've been on here. But any final words you have for either your opponent or the people in Salt Lake County?
My opponent refuses to debate me. I approached him even when we were discussing whether or not there would be a debate with a very disingenuous reporter. After that interview was done, Sim Gill happened to be coming around the corner at the same time. So I had finished that interview and I walked up to him to shake his hand and to invite him to debate. And he ran away. He straight up turned his back with his people, looked over his shoulder and kind of booked it down the street. So I was like, okay, well, I tried. But that Salt Lake County is the response that you can expect if you decide to re-elect Sim Gill. Every single time you have a question, every single time a victim approaches him, every single time a reporter wants an answer to these very serious questions that I posed, you can expect Sim Gill to run the other way and to look over his shoulder while doing it to see whether or not you're chasing him down for those answers. He is a man who does not accept responsibility or accountability. If you think that a 46% increase in homicide in the past 4 years is in any way acceptable in Salt Lake County, if you think that criminals deserve a 50th chance and another opportunity to re-victimize the community, then yes, vote for Sim Gill. But if you're ready for true accountability and to see a decrease in crime simply by prosecuting these cases and holding criminals accountable, then vote for me, Danielle Ahn, this November, and let's make Salt Lake County a safe place to live.
Well, thank you. You're always welcome here, as I said, anytime, whether it's before the election or whether it's at your victory celebration. If you are voted into the office of the brand new Salt Lake County District Attorney's Office. Whatever the case may be, always welcome here. Always a pleasure. Thank you so much. And I look forward to seeing you again.
Thank you so much, Jeff. I really appreciate the opportunity.
Bye.